Good morning and welcome to this latest webinar from thebusinessdesk.com in partnership with Walker Morris and Armstrong Watson. I'm Ben Ormsby and I'm the Yorkshire editor, and over the next 45 minutes I will be joined by an esteemed expert panel who you can see around me, and we're going to discuss partnerships, the good, the bad, the in some cases challenging, as we look at minimising the fallout from your fallout. Before we get started and I ask the panel to introduce themselves, just a quick bit of housekeeping. Please, if you would like to ask any questions at any point, do so using the Q&A button at the bottom of your screen. And also, we will be having 2 polls during the session. So simply click the answer you want and share it. It's anonymous, so no one will be holding you to account. But we want to hear your thoughts as we get through into the discussion. So without further ado, let's get on with the introductions. And I'm going to start with you, Louise, please.
Hi, so I'm Louise Norbury Robinson. I'm a senior associate in Walker Morris's commercial dispute resolution team. So we have a lot of experience in our team with dealing with fallouts of partnerships, also company disputes too, which we'll hear about soon.
Perfect. Lindsay?
Hi, I'm Lindsay Odean. I'm a director in the same team as Louise, so commercial dispute resolution at Walker Morris. I've been there for couple of decades dealing with shareholder and partnerships disputes, all sorts of sectors and clients, so family disputes over land, farming disputes over land, massive corporate shareholder disputes over big machines that crush aggregate, through to estate agency partnership disputes and all sorts of things really over the years. So a very wide range of partnership and shareholder disputes. And with those, I've advised clients through proceedings through trial to get final results, but also more often than not, just dealing with resolving them through negotiation really without prejudice discussions on mediation.
Perfect. And then lastly, Matthew.
Hi, I'm Matthew Gale. I'm head of forensic accounting at Armstrong Watson. I've been a forensic accountant for over 30 years. So in that time, I've been involved with a lot of disputes, either between individuals or businesses. On a personal level, I've also been a partner for 29 years. So clearly I'm the oldest person on the panel. But again, I mean, that's in a variety of businesses, from my own business where there were 4 partners to a large accounting practice where there were over 300 partners. So I also bring some personal experience and perhaps pain from previous ventures as well.
Perfect. So let's get started then with the first question. Obviously, you've all outlined that you've been part of dispute resolutions, and you understand that many of the founders start out perhaps with the best intentions. So the first question has to be, are there any common themes and patterns when it comes to these causes of business disputes? And I'm going to stick with my order and start with Louise again.
Hi, thanks, Ben. Well, I'm a typical lawyer answer to sit on the fence, but experience does tell us that every dispute is different. It's a unique set of facts, unique set of people. But there are some common themes, and the main one really is breakdown in relationships. And importantly, that's not just about the business relationships. It can be about the personal relationships within the business as well. But also disagreements about the direction of the business, increasingly commonly actually where different generations perhaps are involved with different ideas. And then perhaps the more common examples that people might think of, so misconduct, mismanagement, a feeling that some partners or directors, shareholders are not doing their fair share, serious perhaps misuse of business monies, and then just generally, at the end, the departure of partners and shareholders and how that's dealt with.
Perfect. Matthew, I guess same question to you.
I think there's a bit of irony with this one, because I think for me, it's often disputes seem to arise around growth, which is to say, the irony is that we all go into business to be successful and usually to grow our businesses, and then actually growth can cause those frictions. And I think, picking up on something that Louise said, I think it's around people struggle sometimes to define the difference between personal friendships and business relationships. And the fact is that most businesses, with a £20 million turnover, will be run differently to those with a £1 million turnover. You'll need different systems, different structures, the role of the key individuals will be different. And whilst it feels a bit fluffy as well, but it's about culture. It's about how people feel engaged with their business. So I think where you've got a business that actually morphs and it grows from a £1 million business to a £20 million business, that growth will bring about change. And there's no way really to avoid that. You know, if you don't change, then that will create friction. And if you do change, it might well create friction. So it's about, for me, it's about recognizing that to be successful, you have to grow. And if you grow, change will happen. And it's about how you adapt to that change.
Perfect. And then on to you, Lindsay.
Yeah, I think I'd agree with both Louise and Matthew on that. We do see common themes, and we do also see these things happening after the business that started becomes something quite different from whatever people envisaged to start with, whether that's through growth or something else. So other kind of changes in circumstance also trigger these things. So, and they're often internal things sometimes. So you might get a change in the circumstances of the individuals involved. I remember having one dispute over a landscape business where the partner was leaving, and he was largely leaving because he'd effectively got into a relationship with someone within the business, and that changed the dynamic between all the partners. So that kind of changed everything and caused a dispute and a breakdown effectively in the relationship. Then you've got other things like when we often find farming partnerships that have been run through generations of businesses, and they might have really large land holdings which have a lot of development value, and then the older partners, the parents, will die, and then it's the siblings who inherit, and that causes the dispute and the breakdown in relationships, and that's a whole different set of external circumstances. And obviously over the last couple of years we've seen the pandemic and Brexit have an impact on people, and that they're completely external factors that people are having to cope with and deal with, and we found that's kind of brought things to the fore. And just on that, we're quite interested to know how people have found that, and whether people have found that their own business relationships have been affected by this. So you'll see the little polls popped up there, so if you'd like to have a vote, if you've got a view on this, but we'd be interested to know whether you are the people are part of the people who've been impacted by this.
Fantastic. And that poll will stay open for a little bit longer, and we'll go back to the results later on. But okay, Louise, sort of picking up on that, the first point you raised in that sort of breakdown in relationships, and obviously without naming names, can you give us some examples? And again, similarly, Lindsay, Matthew, just jump in and give us some suggestions of how these could be perhaps avoided as we go on. But yeah, firstly to you, Louise.
Yeah, sure. So as Lindsay alluded to, actually, one thing we see quite a lot is a family business. So, for example, a family partnership, a farming partnership is something we see quite a lot of in the agricultural sector. But also in relation to, I'd say one example I had was a partnership, and it was a car dealership. And one of the disputes, the areas of dispute was in relation to the ownership of the land, which Lindsay alluded to. And just a misunderstanding essentially as to how the legal title, so that how the property was owned and who owned it, because of course the people involved go to the forecourt, they go to the physical building, the land, the forecourt, and it's pretty obvious that land is only used as the car garage, the car dealership. No one's living there or anything like that. So when a dispute arose, one of the big factors was who actually owns this land, because I think that certain of the partners just assumed that it was part of the partnership, and because those conversations weren't happening at the outset, it wasn't known. And of course the person who actually had the legal title to the land was very much of the assumption that it was his land, his property, but it was used for the benefit of the partnership, and therefore he should be getting some further remuneration from that. Whereas on the other end of the scale, you've got the other partners who believe that it was a partnership asset and they should be benefiting in that way. And that's something that happens quite a lot in partnerships, because a partnership itself, a bare partnership is not a legal entity. It's not a personality that can own the property. So by definition, it has to be in the name of the partners, or a partner, some partners who then hold it on trust for each other if it is partnership property. So that was something that came up for me, where just a lack of understanding at the outset as to what basis, on the basis on which the partnership were using the property, and how the partner should be remunerated for that.
Well, I guess that takes us back to that point that when businesses start out, they start out with goodwill and the view that they're going to go for growth and they're in it together. You know, how can you mitigate perhaps those challenges, you know, Lindsay, when you're starting out?
Yeah, I mean, I think that is that kind of hopeful attitude at the start of the assumptions that people make, and that the people think they're all on the same page, are often what lead to the disputes later on. And the thing is, you know, if it happened a year later that everyone fell out, maybe the assumptions, you'd be able to get through them easier, but often we're talking many years. So I mean, I've had one a while ago where we were looking back 50 years to try and decide, you know, see what the partners actually intended at the outset. I've got one at the moment where we're looking back 30 years. So you know it's even if the parties did have an understanding at the time, it doesn't necessarily mean that it's easy to show when you actually get to the point where someone's trying to say, well, no, this is what we agreed. And the way around that really is to agree it, and to have some, you know, have the conversation, speak to each other about what you intend in relation to the property. Is it the case that one person does own it and the partnership's just going to use it? Or is it the case that actually it is going to be owned by the partnership, held on trust in one name, but you know, actually belongs to the partnership gets the benefit of any growth in the value of it. But all of these things, if you put them in writing, then they know that's the ideal. So we would all say, obviously, as lawyers, as you'd expect, that, you know, ideally it'd be in writing in a full formal agreement, and you would have all that set out. But it's a very minimum, if you feel you can't do that and get the conversation that far, just having some kind of paper trail or some kind of writing trail as to what everyone's intentions are, you know, can really help further down the line to avoid the conflict, or at least take one issue off the table.
I enjoy that positive look of it. It takes at least one issue off the table. There might be others, but we can deal with those as the conversation goes on. Matthew, have you got anything to add to that?
I think, you know, it's very easy if there are people watching this who have just set up their own business and they're probably feeling very insecure and perhaps a tad paranoid now. But I suppose the example I've got is actually my own, really, if I'm going to name names. And it's to do with the fact that when we set our own business up, you know, it was a great time of my life. It was exciting. I've never regretted it. But looking back, you know, hindsight's a great thing, and you can look back and learn from that. And I think there are two things that I thought of, again, the benefit of hindsight. The first is that I think when we set our business up, you know, we wanted to rebel against the structure that we, you know, from our employment that we came out of. So, you know, we had this sort of hippie commune philosophy that we were going to kind of have very loose structures. You know, we thrived on informality. But actually looking back, as much as fun that was, there was probably a lack of accountability between ourselves, and also perhaps less direction for business. So it always felt to us that the minute you started to put that structure in place, you were kind of tarnishing the spirit of what you tried to do. And you know, as time went by, we got better. We did put structures in place. You know, the hippie commune didn't last forever, but it was just that fact that you kind of felt like almost you were going against your original principles. And I think when you look back, you realise that isn't the case, that actually some element of formality and structures can be your friend, and they can really help moving forward. I think the other issue is that it's perfectly natural to almost instinctively not want to do some of this stuff, because when you set a business up, or when you have some significant involvement, it's more than just a business. You know, it's personal to you as a business owner, and you care about that business. And so the risk is that when you make decisions, you make those decisions probably with your heart rather than your head. And someone coming into your business would be more likely to make a head decision rather than a heart decision. So again, looking back, I think that's something in terms of how you define roles within a business. You know, you want to empower people to make business decisions, but at the same time, you know, hearts are great, but they shouldn't rule your decision making.
I agree. There's a place there, but I'm also slightly caught off guard by the hippie commune comment at 10:15 on a Wednesday morning. There was many comments I was expecting, but that was not the first one I was pitching there, Matthew. But as we move on, you know, we can talk about partnerships, but there's obviously there's different vehicles that compose very different challenges. You know, so partnerships we've started with. So let's stay with that one. You know, have you seen any particular issues recently, Lindsay?
Yeah, I mean, I think with partnerships, the common things that we see generally arise as as a result of there being a lack of a written agreement or any written agreement not being up to date. So with partnerships, if you don't have a written agreement, you will still have rights and obligations between your legal obligations, but they come out of the Partnership Act from 1890, which is quite a simple document and obviously a very old document, and gives kind of presumptions that apply if you haven't agreed anything to the contrary. So if you haven't got any evidence of the fact that you've actually agreed something different, then you can find that what you didn't intend to happen is actually where you are. So it can give people quite a shock. So so things like the fact that one partner can just terminate the partnership, it will, because effectively you're seen as being in there voluntarily, and you can be in a partnership without knowing it. All that's required is that you're in business for the purposes of making profit together, and then you're taken to be doing everything equally. So you might not even know you're in a partnership. I remember I was a trainee. I should say at this point it was not my case, and it's not someone who's still at Walker Morris, but I remember being in court where everyone was ready. We were ready for a trial. Both sides were there on the basis that two people were shareholders in different companies that held properties, and the judge just looked at the paperwork and said, well, this is a partnership, isn't it? At which point everybody in the court kind of looked around as if to say, is it? Because nobody thought it was. And anyway, we never found out what the judge thought about that, because actually it settled pretty quickly after that. But it gave everyone a bit of a shock, because people didn't think it was a partnership, and the people who involved it certainly didn't. And maybe it wasn't, but you don't really want to be in that position. You want to kind of know what you're in. And the other thing is something I mentioned earlier. You could have an asset that actually you think is yours but is used for the partnership, and then you decide to sell it, and you find that the value of the uplift in the value of that belongs to the partnership and not you. You might find that your partner binds you to something and you don't realise that they can do that. They have the authority to bind you without you agreeing to that as part of the Partnership Act. And then if someone wants to leave, there are kind of rules about selling the property off, whereas, so you could end up with a breakdown of a business where actually one of you just wants to leave. And in other circumstances, one person might continue with it, but actually the fact that you haven't got a written agreement means that you can't do that anymore. So there's all of those kind of issues that kind of come up that are avoidable if you can have the conversations at the outset. And it's the stuff that Matthew will deal with about how people get repaid their capital and what happens on the other side of it that can cause real issues if you haven't got something in place.
I love the fact that in the 2020s we still look back to the 19th century for our 20th century for our legal advice on partnerships, and I'm slightly terrified of the fact that I could be in a partnership now and not know about it. I'm going to be going away and double checking everything I've ever done in my life. But no, Matthew, Lindsay teed you up nicely there to talk about the financial implications of it and how you can go about getting that capital back.
Yeah, I mean, thankfully I don't remember the Partnership Act coming in, which I am grateful for before anybody asks. Yeah, I think the thing with partnerships is it just kind of sometimes feels a more personal structure, which again can lead to frictions and tensions. And just picking up on Lindsay's point, the joint and several is quite a big thing, either because people don't understand it and therefore they don't understand the decisions of one partner can bind the others, or it can just be because you are totally paranoid that you're all on the hook together for something. So businesses that have particularly long, maybe leasehold obligations can be an issue. Obviously now we've got the LLP structure, which again, there's probably a piece of legal planning around that in terms of encouraging people, if there are serious obligations that maybe you want to convert, have some sort of LLP structure and therefore reduce the potential risk to the partners. But there's even things like, PI premiums, professional indemnity, have skyrocketed over recent years. And so, partnerships might be tempted to put themselves on the hook for bigger excess, or rather than one excess per year, they might be on per excess per claim. And those sort of decisions then, if someone does have a claim, it's a big claim, it can impact on everybody. So there's certainly things around that can impact viability-wise. I mean, from a valuation point of view, I think the one thing that people sometimes misunderstand is the difference between a business that generates a very healthy revenue and generates a good profit for the partners, as opposed to actually a capital value, some sort of goodwill that if you leave, and you see this because it is an issue, and because of the very kind of personal relationships that you get in a partnership. many professional partnerships often have a clause in the partnership agreement that say there is no sale of that goodwill, that the goodwill sits with the partnership. So as an outgoing partner, you can earn very good money, but actually when you leave, in many cases, all you're entitled to is, the capital that you have in the business and any profits that are accrued up to the date that you leave. And sometimes we see cases where a particular partner believes that their share of the partnership should be worth something, but actually in reality, it can even say in the partnership agreement, it's not worth anything. So something like, doctors' practices, for example, doctors' practices, when you leave, you just simply get your capital and your profits. There's no sale of goodwill. And a lot of law firms and accountancy practices are set up in the same way.
That's fascinating. And I guess then, let's take another sort of vehicle and go, are the issues that we've talked about there the same when we're talking about limited companies, or are they completely different? And again, I'll go to you first, Lindsay.
Yeah, it's different, but we see similar themes in terms of the personal relationships, but the structures are really quite different. So there's also LLPs, but if we just kind of we've done partnerships, so we'll do the kind of the main one, which would just be you incorporated company, limited company. So it's a bit different with them in that I suppose as with the Partnership Act, you do have a kind of backdrop, so you have an automatic kind of back position, but it's more detailed with companies because you automatically get a certain set of articles of association with any company, which is basically the rule book for your company, and that will set out a fair amount of the detail around who can do what, and who the directors, what the directors can do and what they can decide and what they can't decide. So that's a little bit better in that way. Having said that, they're not tailored. So again, you can end up with these issues of them not suiting the business or not actually reflecting what you think your company does, and then you've got an extra layer of complication in that your right to sit behind the company, you're just a shareholder in the company. It's not a kind of direct right as well. So often you might feel you've got a claim, but actually only the company has the claim, and then you have to do something like see if you can bring a derivative action, which is a claim through the company, or see if you can bring an unfair prejudice petition where you effectively thought you could participate in the management of the company, and for some reason you're not, your rights aren't being adhered to. So it kind of complicates things in some ways, but simplifies other things. The thing we see quite a lot with shareholder disputes is there'll be a quasi partnership company. So that's kind of funny sounding word, basically means that it's a company that's similar to a partnership, and the court kind of treats it differently and treats all the partners as the directors and shareholders as being more involved with each other, and you have an extra layer of expectation there, and extra layer of rights and obligations which you don't necessarily have otherwise. And again, we kind of see common themes with them. So we often see where one partner has generally had day-to-day control of the run of the company, and then something happens, and another director or shareholder will see that something's happened that they're not happy about, or their remit's expanded, someone feels pushed out. But again, it's generally around expectation and things changing and misunderstandings about the authority of what one person can do. So if you've not agreed, for instance, that director who's got day-to-day conduct can't enter into certain agreements, so can't take a charge out of a property, can't mortgage it to the hilt, and then they do that, then obviously that's a bit of a shock if actually there's nothing legal in your agreement or in your articles to stop that. So in those circumstances, we see a split board, and if you've got standard articles, you might find that there's you and one other person. If they're the chairman, have been allocated to the chairman, you think you should be in deadlock, and actually they can outvote you. So it just depends on what's there, and it can have quite an impact on where you end up. So similar to partnership, but with a whole different construct over it, really.
It's always interesting hearing about those sort of moments where you've got split boards and issues of that. How have you got any other examples or any other issues where that's occurred, perhaps, Louise?
Yeah, certainly. So I mean, you say that's a split board, but it's interesting because it's not just about the board of directors. It's quite commonly with a shareholder disputes element as well, which may well be the same people or a combination of some of the same people, especially in sort of homegrown family type businesses. And in that situation, there's probably sort of three categories of cases that we'll see. So where we're acting for the majority shareholder who needs the support of the minority shareholder and doesn't have it, or the other side of that same coin, You might be acting for the minority shareholder who's perhaps feeling pressured by the majority shareholder and doesn't agree, but feels, perhaps doesn't have the requisite voting capacity to do anything about it, and wants to bring an unfair prejudice petition. Or just acting where, as Lindsay alluded to, where the shareholders have just reached deadlock and there isn't that mechanism to resolve that. And again, the documentation underlying company legislation, if that's what you're left with, will govern what the shareholders can and cannot do and what options they've got to either block certain actions or be bought out or whatever. But it's important that, as Lindsay says, that those documents are tailored to you, because sometimes where deadlock's reached, the only option might be to wind up the company, which sometimes might be appropriate. But, in a long-running, well-established business, obviously there's certain stakeholders that are going to want to avoid that. And then we also do see the interlinked director and shareholder disputes, because if there's people are the same people, same underlying individuals that are on the board of directors and have a shareholding in the company, and even more complex than that when you see the company which has also got a partnership. So as Lindsay alluded to, either a quasi partnership or sometimes an example I've got is where you've got a limited company, the same group of people operating a limited company and a partnership. Usually, two different businesses that perhaps complement each other in some way, which means, you might have, for legacy tax reasons, that distinction, but in practice, the accounts might say one thing, but in practice, the lines can become quite blurred, especially if these people are not necessarily on top of the legal structures, and everything all works obviously harmoniously until a dispute arises, and then questions are to be asked. And what we often see is that particular individuals, especially in a family situation, but not always, particular individuals might feel an allegiance to the aspects of the business that they've been working closely with over the years, but it doesn't always follow through that's how it will flow on an exit, or on a carve up, usually because the businesses have evolved and that sort of thing. So that's an interesting one we see quite a lot.
Matthew, I could see you nodding along there, so I'm gonna go to you because I'm sure you've got something to add.
I suppose there is another angle to this, because we focused a lot on the internal relationships about fallout, so shareholder directors, which is absolutely right, but also as it's this change piece around growth and everything else, which is also getting your external relationships into good order as well. So the way that you operate with your bank, your customers, your suppliers, and we sometimes get involved in matters where clearly the company hasn't involved their external paperwork and their structures, which can cause problems. So we recently acted for an artisan gin company, which some jobs do have their perks, but this gin company had started in 2015. It was just literally a family-run business, kind of more of a hobby that was morphing into a business, and very low turnover. And they had an informal relationship. They met up with someone who ran a wholesaler sort of distributor arm, and because they got on personality-wise, the wholesaler said, "Well, look, we'll try and get your gin picked up by some of our account holders," and that went along quite nicely for a couple of years, but sales were still very minimal. And then all of a sudden, one of their gins, one of these particularly flavoured, kind of unique-looking gins, got picked up by some bloggers. I think it was actually like a mum's blog, believe it or not. But this gin went viral overnight, crashed the website to the point where in the run up to Christmas, they did 1.7 million in sales alone in 1 month. And that year, 2018, they were over 7 million in turnover. So literally in 3 years, massive increase. But what happened over the course of 2018 was that the increased stresses and strains on both businesses, just, if you can imagine how many bottles of gin, 7.3 million pounds worth, it's a lot of business. And our client was having to scale up and deal with stuff. The other company was. And what happened is that the relationship started to become acrimonious because people were having to change the way it was set up. And they fell out, and our client it's kind of stepped away from their agreement at the back end of 2018. Our client then sued because they had £600,000 worth of stock which hadn't been paid for. So they sued there. The wholesaler distributor countersued on the basis that they argued that there was an informal contract between the parties, and that informal contract meant that our party should have given them at least 12 months notice of any termination. So they then countersued for all the profits that they said that they would have made over the following 12 months. And bearing in mind how, I think most people know, gin sales are just up and up and up over this sort of 2018, 2019 period. So suddenly you've got two parties going at each other. And, something that started very well was very sour, very bitter. And you look at the costs that the parties both incurred, lawyers, accountants, barristers. You do wonder whether, if there had been a contract in place, if there had been a little bit more structure and formality around those external relationships, whether you would have had quite the issue that we had. But yeah, so there is also that external aspect as well to this.
I feel it would be remiss of me not to say, so that's a case of gin being more partnership ruin rather than mother's ruin. A slight pun, but that's a really interesting aspect. And I guess we're going to go back now to that poll because I feel we've got to talk about it. The last 24 months have probably brought about added pressure for everyone, but not least those business owners and managers, because we've had, as you alluded to at the start, Lindsay, Brexit, and then the bit that none of us foresaw, the COVID-19 crisis. So it's created volatile market conditions. And how can these unpredictable situations, perhaps be prepared for by, correct agreements and when we're starting out, and how can we look, if you've not done it now, to improve the outcome? So yeah, I'm going to go to you first, Louise.
No problem. Yeah, I'll keep this simple. You hit the nail on the head, really, Ben. So starting the point is, firstly, what am I? Am I a limited company or a partnership? You should know if you're a limited company. But am I a partnership? Am I a quasi partnership? Even though I think I'm a limited company. And what does the documentation say? And does it reflect? Does it reflect the reality? So it should be a shareholder agreement, articles of association for a limited company, or a more formal partnership agreement for a partnership, etc. And I know it's cheesy, but start with the end in mind. I know we said that in some of the literature that went out for this, but it's true. People are forward looking in business, but not to the end looking. So yeah, start with the end in mind, really, and keep that under review. And I think diarising, so as businesses evolve and run with them, and they might take different directions, and it's exciting, etc. It's very easy to miss those regular opportunities just to take stock. Where are we? Where are we going? Do we still do things still work in the way that they did before? And just diarise, maybe annually or whatever, just to review, or if something big happens, like Matthew's gin company overnight, just building some time. Easier said than done, I know, but building some time just to diarise and just take stock, sit down with your partners, with the directors, with the shareholders, as the case may be, and just take stock and make sure that things are still working and the documents are still reflecting the reality as your business and the markets have evolved.
And I guess, Lindsay, sort of picking up on Louise's point, planning at the start is great, but we're not all very good at looking to the end when we're at the beginning of anything, I think is safe to say. Is there anything else you think you should add for if you're already in that business relationship and you're thinking now, actually, I need to maybe get my ducks in a row?
It's not too late. I think the message with all of these things is that generally where you are and what happens in the future, you can agree. There's very few circumstances that you can't kind of contract out of, so you can generally agree between you how you own things and what happens going forward at any stage, and you can document that. So it's obviously more difficult sometimes to raise that at a later stage, but it's always going to be the most difficult time to talk about it if something's happened and gone wrong and you're concerned about it. So if at all possible, try and have the conversations before then. And, you know, I'm not saying it's easy to bring these things up, but often we find that people will start looking at their relationship and regularizing things as growth is occurring. Or it might be that someone external, like their accountant or someone, will say, look, you know, you should think about documenting this. Or also that you should think about changing things, because even if you have the conversations at the outset, if things change, then actually you may need to alter your agreements to take that into account. And one way for people to kind of look at this is maybe look at what kind of factors can you see in your relationships and external factors relating to your business that might change. So if you can see, for instance, that there's someone involved in your business who might, you can see that they might have a life change at some point, or the idea is always been that they might leave, or if you can see something, that's sometimes a way in, to say, okay, well, in these circumstances, what do we expect to happen? Actually, what about these circumstances? What would we expect to happen then? And sometimes just as you start to think about what might happen, that's what opens up the conversation about who owns what and what you'd expect to happen and who actually can make these decisions. And are there any things that, okay, we can all do everything, but are there any things that aren't acceptable? So sometimes you see in partnership agreements or on shareholders agreements lists of things that people can't do, so they can commit they can commit the company for something up to 50,000, but not above that, or specific things that you can carve out. And ensuring that's up to date is important. And we know when we see this, and we see people's relationships changing. And we've had a tech startup example recently where we had, at the start, everyone's very enthusiastic. Both people are really involved in the tech, really actively involved in it. And then, one of the stakeholders becomes less involved in the kind of dynamic part of the business, for want of a better way of describing it, and becomes more of a management support role, to the point where actually it's probably not right that it's 50-50 going forward, and they don't actually really expect that. So at that point, you can change the structure to suit them and to reflect the current circumstances, and I think just having those conversations and communication are the key to it, really.
No, it's interesting, isn't it? These sorts of conversations are never going to be easy to have, but you've got to pull the band-aid off and have them at some point. And I guess, Matthew, these agreements we've talked about, how can they impact the valuation of a business? How are they looked at?
Yeah, I would just to go off piece for a moment. I mean, I totally agree with Louise in that I think the key here is to just almost that continual review, that if you can diarise something, because when you start off, it all seems a little bit of overkill, and you might not have the money in the ideal world to pay lawyers and accountants to do all these things. But I think, as you say, these life changes, you think of us in business 2 years ago, a lot of us had very different mindsets to what we have today, and that's only in 2 years. So I think having some sort of, whether it's a board meeting or whether it's just you sit down with your fellow participants and you just review it. It's almost a bit like the typical kind of SWOT analysis: strengths, weaknesses, opportunities, threats. It's really looking at those honestly and saying, what's changed, where do we think we're going to be, and are our systems and processes adequate for that? So I thought that was a really useful point that Louise made. In terms of valuation, I mean, that's obviously a huge topic, and I don't want people to glaze over in this webinar when it's going so well. So that's maybe one for another day. But in terms of us, I mean, we look at a lot of these things, as I say, when pretty much we're all about cure rather than prevention by the time it gets to us. And if a shareholder's left a business, if they died, if they're ill, then we are tasked with trying to value the business. And usually, I mean, most businesses you would like to hope are valued on a sort of an earnings multiple, that where they're profitable, someone buying that business would be buying, a future pattern of hopefully positive cash flows. I think in terms of the documentation, it just irons out some areas. No documentation is ever going to be watertight. It's never going to foresee every possible outcome that might happen. But where you've got, for example, a good shareholders agreement in place, you've maybe got a mechanism prescribed for how you value those shares in the event of a shareholder dying. You might want some preemption rights in there, so the process by which those shares have to be offered for sale, so it gives the remaining shareholders some control over the process. Just some good, clear terminology And that can make a massive difference in terms of just, trying to get a value on a business. And one area I think that sometimes isn't addressed enough is the question over minority discount. I think put simply, a minority discount is where a party doesn't own a controlling interest in those shares. Then if those shares are sold separately from the other shares, you're very unlikely to get full market value, because someone buying those shares isn't going to have any control either. So if you sell it, if the whole company gets sold, then you will get effectively at least the value of your shares, or even a premium by selling the company as a whole. But where you're selling just a simple tranche of shares, so minority discount can get very contentious. And a lot of shareholders don't realise that if you own 10% of shares, you don't get 10% of the value of that company, that there will be a discount applied. And that discount is wholly arbitrary. There are guidelines in terms of what that might look like. But I think there, you can cover that point off. Some contracts that we see have what's called good leaver, bad leaver provisions. So, if someone dies, you might have a good leaver provision that actually says, we're not going to apply a minority discount. You are going to get 10% of the value of the business. You might have a bad leaver where if someone's being found to be doing something unscrupulous, or nicking a bit of money or whatever it might be, well, then in that case, then you would apply a minority discount. So it's never an absolute catch-all, but you're just minimising the areas, I think, that could be more variable, and trying to nail a few things down.
No, thank you very much. And going back to that poll, the second poll is coming up, but just so that everyone can see the results of the first one, it was 2/3 said that yes, the last 2 years, the big issues of the last 2 years, we'll call them, COVID and Brexit, had impacted their internal business relationships. Well, hopefully, over the course of this webinar, you might be getting some advice on how to actually move things forward and address any of those issues. The second poll is actually dead simple. We want to know, looking ahead to 2022 and beyond, how optimistic or pessimistic you're feeling about the economic climate, over the next year or so. I'm going to be honest, I'm 100% in a glass half full category, because you should always try and look on the bright side of life, as they say. But we'll leave that open as we go to our last question. And this one's probably the one that everyone really wants to know is, what tips or top tips have you got for business owners looking to the future now? How can they prepare for, the unknown is probably the biggest way we can refer to it these days. So starting with you, Louise.
Thanks, Ben. Yeah, I think my top tip, I'll try and keep it to one, would be linking back to what I said before, I think don't be afraid of difficult conversations. You can bet your bottom dollar that what you think is going to be a difficult conversation now will be a lot more difficult if you're in dispute with the person you're trying to chat to about it. And if you're worried that, that might cause tension if I raise that, well, it's difficult perhaps, but that's the exact reason to raise it, to make sure that, whilst you and your business partners, business associates are on the same page at least. That's the time to have those difficult conversations, when you're both committed to resolving it, getting an agreement and moving forward. The same is not true when you're communicating through two sets of lawyers, when there's a lot more at stake. So, and also on the back of that, in terms of difficult conversations, don't think of it as a negative of, we're talking about, doom and gloom, what happens when we fall out. It's not that. It's pretty certain that all business relationships will come to an end at some point, either through retirement, through death, through changes in circumstances. It will happen. So it's almost, you're planning for that, having those conversations now about something that you know where you are in the future. And it's not, as Lindsay says, it's not something that's set in stone. You can constantly reassess and change those perceptions if need be. But I think, why not check your documentation if you're not sure it does what you need it to. Speak to each other now and get aligned and get a structure in place.
Perfect. Same question to you, Matthew. What's your tip for the future?
Well, I feel like I should come back to the hippie commune. So I will say that when we were setting up our partnership, we consulted with someone who was much older and wiser than we were, and we kind of said, do we really need a partnership agreement? And he sort of, I'm paraphrasing slightly, but he said to me, Matthew, these things are not for the days at the start of your business, when you're all running through glades of spring flowers, holding hands with your fellow shareholders, directors, singing Kumbaya. It's about providing for the days when things change, and it's exactly like a will. It's not nice talking about it, but it's better to have plans in place. So I think really, it is a bit of tough love here, which is, it's going to happen. So don't hide, acknowledge it, and deal with it as and when you can, because ultimately it will be better for you if you just keep your head out of the sand, really.
Perfect. And then lastly, to Lindsay.
I think Louise and Matthew, that's exactly right. They are the top tips, and I can't compete with Matthew's imagery, obviously. But I think beyond that, the other thing I would say is really look at your business, really understand what it is you own, what it is you do, where is the value in your business, what is it that you've got to protect, and then the second thing, I think people do that often, but I think the second thing that people don't do and probably should is really think about their expectations. So, what are their expectations of that business? What would they expect to happen in different circumstances? And what would they expect, how would they expect to treat each other in those circumstances and their fellow stakeholders in it? And to really look at that. And with that in mind, in a terrible segue, we've actually put together a checklist of things to think about, and the kind of the types of things to assess and to really kind of help you with those conversations, to have those conversations and to start that ball rolling and to really kind of think about where you are. And we'll circulate that after this, but it kind of runs through similar themes to the ones we've discussed on here, but it really kind of just hopefully helps people think about that, what they would expect as well as just what they have.
Fantastic. And that checklist will also be available on thebusinessdesk.com. I have to get the plug in there. It's part of my contractual agreement. But just as an aside, the results are in, and I am very happy to say that the majority of our viewers are in my camp and are glass half full. So yes, let's all hope that 2022 is a year that perhaps goes against the trend of the 2020s so far of being one of challenges. But equally, remember that your business, just like life adage is, it has a start, it has an end, and you're going to pay a lot of tax in the middle, so start planning for what happens at the end. And that wasn't scripted, but thank you very much to everyone who's joined me. Thank you to our sponsors, Walker Morris and Armstrong Watson, and to our panelists. If you do have any questions after this, I'm sure they will be happy to field them via email, or send them through to me at thebusinessdesk.com and I'll pass them on. But no, thank you very much, and I hope you all have a fantastic day.